So another New York concealed carry case is up at the Supreme Court level seeking review. So let's talk about this. But real quick before we jump into this video, if you agree that the Supreme Court needs to hear more of these Second Amendment cases, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. If you're not aware, USCCA is going to have an expo here really soon. It's going to take place from November 11th through the 13th. If you're interested, I would love to see you there. I'm going to be there with a lot of other content creators like Jared from Guns and Gadgets, Braden from Langley Outdoors Academy. Usually we're walking around together. So if you're interested, check out the USCCA Expo. I will leave a link down below for all the information that you would need. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we'll be discussing another New York concealed carry case that is currently seeking Supreme Court review. The case we'll be talking about in this video is called Baldia v. the City of New York Licensing Division. This case arises out of the old standards that New York and the City of New York used to have when they grant or denied concealed carry permits, and that was the proper cause standard. This case, Baldia, was the result of the licensing division in New York denying an individual an unrestricted concealed carry license, even though he was a police officer after the fact, and also they said that he did not meet the proper cause standard, therefore they did not renew his permit. Now, for those not aware, there was a prior case which already struck down the old New York concealed carry scheme, the May issue permitting scheme, and that was the New York State Rifle and Pistol Association v. Bruen decision. In Bruen, the Supreme Court struck down the New York May issue licensing scheme, finding that it was not consistent with this nation's history and tradition. One of the primary findings of the Bruen decision was that the government bears the burden to prove that their restriction is based in history and tradition of this nation. However, despite that decision, the state of New York rushed through a new law called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their concealed carry laws in response to that Bruen decision, the state of New York decided to double down on gun control and created a scheme that was even worse than the one that existed prior. That change in law is currently being challenged in multiple cases right now. Probably one of the most popular ones is the Antioch case. We covered that at length, so if you're interested in that, you can find videos here on the channel covering that. But just understand that there used to be the proper cause standard in New York that was based on the whole May issue licensing scheme, proper cause. Then after the Bruen decision, they changed their law, and now the new law is the new law under the CCIA. This case, Baldia, is a carryover case from the old New York May issue scheme and the proper cause standard. The petitioner in this case, he filed it pro se. He filed a pro se writ of certiorari, which essentially just means he's doing it on his own. He doesn't have an attorney. So some of the facts around his case are a little bit blurry because he filed this pro se. But what I can gather happened is he was denied a renewal permit. He had a permit initially issued to him in 2012. It was renewed a few times, but later, I believe it was in 2018 or 2019, he went to renew his permit and then it was denied. His renewal application was denied on the basis that the licensing division did not believe he had proper cause to actually be granted that renewal. In reaching that determination, the licensing division found that Mr. Baldia is not in danger in the same way that a diamond dealer is. A diamond dealer, they said, who has to walk down the 48th Street with a briefcase of precious diamonds is at a greater risk than Mr. Baldia here, and on that basis, they denied his renewal and found that he did not meet the proper cause standard. He then sought a reconsideration of that denial of the permit and ultimately decided to sue the licensing division because he believed that their determination that he did not have proper cause to be granted the renewal was a decision made that was arbitrary and capricious. This case then made its way through the appellate process, where the courts found that the denial of the licensing division, the denial of that renewal application, was not arbitrary or capricious. However, while this case was going, and during the lockdown period, Mr. Baldia was then hired by a municipality near his own home and became an active sworn police officer. Despite being a police officer, his unrestricted license to carry has still not been granted. Now, Mr. Baldia is seeking Supreme Court review of his case, and the main question he presents for the Supreme Court for them to review is whether the license division is empowered to deny an unrestricted concealed carry license to a qualified police officer who seeks to apply for such licensing. Mr. Baldia argues that the prior proper cause standard led to an invalid determination that he should not be granted a permit. Even more so, now he says that he has greater basis for the denial being improper under the Law Enforcement Officer Safety Act, or the LEOSA Act, and he believes that his denial by the licensing division should now be determined to be improper. Now, in the last video when I talked about this case, many of you commented, why did he even need a permit if he's law enforcement? That's because he had a permit granted in 2012 and was renewing the permit, and this all happened before he actually became a law enforcement officer. Although he had a permit since 2012, the licensing division randomly decided not to renew his permit in 2018. He later became a police officer while this case was going, but even then the licensing division still has not granted him his renewal. The LEOSA exemption likely still applies to him now, but some of you may be asking, why does he even want a permit still? And I assume maybe the best answer for that is he just simply wants a permit, and maybe he's just proceeding with this case out of principle now. In reaction to his petition for the Supreme Court to review this case, the New York Licensing Division has filed their response, and they are arguing that Baldia's challenges to the denial of his license application does not properly present any questions of federal law for the Supreme Court to review. Although Mr. Baldia now seeks to challenge the denial of his application under the LEOSA Act, that statute made no appearance in his initial filings, according to the Licensing Division here in their response, and they argue that that did not appear until he was actually going through the appeals court process. The Licensing Division here argues that this whole issue of the LEOSA did not pop up until after he was denied his permit. He didn't become a law enforcement officer until after the denial of that permit and after this case was filed. He didn't properly plead it, likely because he was pro se, and they believe because of that this whole case should be now denied by the Supreme Court. They also point out in their response that Mr. Baldia to this point has not filed for a new application for a carry license using his police officer status. Then the Licensing Division argues similar to how I said they would in the last video, which is that after the Bruen decision, the state of New York has changed their laws and they passed the CCIA. The CCIA removed that proper cause standard and created a new concealed carry application process. The CCIA also stated that anyone denied of a permit under the old scheme could reapply within 60 days without having to pay additional fees. The Licensing Division is using the new concealed carry laws in the state as a way to say that this case is now moot, that the arguments are moot, and that this case should not be reviewed by the Supreme Court. Now, since this case is a carryover case and a carryover review of the old proper cause standard, I can see this kind of going a few ways. The court can, of course, just deny cert altogether, which is very likely. Most cases that are petitioned before the Supreme Court for certiorari are often denied cert. There are a ton of cases that are presented to the Supreme Court. They only take a few every single year. They take more than a few, but they only take a select amount every single year, and they actually deny more than they actually take. So I can see this case just simply being denied cert. The court can also deny this case because some of the issues raised by the Licensing Division, like that this case is now moot because the new law, the CCIA, has changed the laws post that Bruen decision. And really the best case scenario for Mr. Baldia is that this case is GVR'd, which means it's granted, vacated, and remanded by the Supreme Court, and is remanded in light of Bruen. And really the issue with that I see, even though that's the best case scenario for Mr. Baldia, the issue I see with that is that this case never really fully raised a pure Second Amendment challenge. It wasn't never really a pure challenge to the proper cause standard. Instead, this case morphed into Mr. Baldia challenging the determination by the Licensing Division based on his law enforcement status under the LEOSA. So I could see the Supreme Court, best case scenario, they could grant, vacate, and remand. But in reality, I see them denying cert in this case just because it never really formed a full Second Amendment case. It might have started off as that, but with the LEOSA stuff, it wasn't properly pleaded. And I think the Licensing Division is going to get this mooted, and they're already kind of presenting that aspect to the court. So I will definitely be keeping my eyes on this case. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, like this video and like support the channel, and the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by Armed Scholars, and this nation will be maintained by Armed Scholars.